Magistrate Eunice Nyutu, mandated with handling the 63 billion Arror and Kimwarer Graft case against former Treasury CS Henry Rotich and 8 others, has declined to bow out of the case on grounds that prosecution failed to prove her biasness. The application by DPP sought to have Nyutu disqualify herself on grounds of hostility towards the prosecution.
Eunice Nyutu is the magistrate presiding over the case in which former Treasury CS Henry Rotich and 8 others have been accused of embezzlement of at least 63 billion shillings in the Arror and Kimwarer Dam project, has refused to bow out of the case as sought by the prosecution. According to Nyutu, the DPP sought to have her disqualify herself on several grounds, top among them hostility and biasness, which were dismissed by the magistrate.
It is my finding that the application for recusal was calculated at compelling the court into granting an adjournment by any means necessary. This amounts to an abuse of the court process. The action of this ruling is that the application for recusal does not meet the legal threshold, and the same is dismissed in its entirety.
In her ruling, Nyutu has dismissed claims by the prosecution, insisting that she has oftenly granted them unreasonably short timelines to procure the attendance of witnesses.
It is therefore strange and inexcusable for the prosecution to demand that they be given time to procure witnesses on a hearing date. It is tantamount to admitting that they only became aware of the witnesses on the trial date. Such practice cannot be condoned, as it is an impediment to expeditious delivery of justice. It is the duty of this court to manage a case in a manner that upholds the constitutional requirements of a fair trial. Delayed justice is certainly not one of them. It is the reason why elaborate trial conferences are held and dates fixed well in advance. The prosecution, therefore, cannot afford to require time to procure and prepare witnesses on a hearing date.
The magistrate, while referring to Section 157 of the Kenyan Constitution, has maintained that DPP's intention to review a case shouldn't in any way lead to suspension of court proceedings, giving a reason why she will not conform to the idea of suspending the hearing.
All the players are usually seated in court ready to proceed, only for the court to be informed time and time again that there are verbal instructions requiring the trial to be suspended, awaiting further directions from the DPP.
Magistrate Nyutu is reported to have taken over the hearing of the matter on 16th of December 2022 from Lawrence Mugambi, who was elevated to High Court. 41 witnesses have appeared before the court, with over 20 being said to have been discharged without testifying in court. The court has 15 more witnesses left. Beatrice Kageha, Look Up TV.
Wiper Party leader Kalonzo Musyoka has urged the courts to